So when you're checking a rule, let's take a look here. Let's say we're looking at Rule 10. This is on page, well, it says page 512 here. It's in about 20 pages or so. You might turn over there with me, where it says withheld judgments in the magistrate division. All right, now these are the rules concerning withheld judgments. But what if the legislature upgraded withheld judgments, and there's something new or there's something taken away? And here you are moving in, and let's say for some reason you want a withheld judgment, and you want to write a motion, and here you are writing a motion and you don't have the latest information, and your motion then is off point, isn't it? It's out of date because the material's out of date. All right? Always check that supplement. Now, going over the rules, if you're not in a federal district court, you're not concerned with the federal district court rules. But let's suppose that the IRS hauls me in now and they're going to charge me with willful failure to file. And I run over and I get my Idaho court rules and I start looking through here now because I want to see how to answer the complaint. See how ridiculous that is? No. Then what I've got to do is go to my local law library, don't I? And I pick up the federal criminal rules. And the federal criminal rules then will apply in the federal district court. But wait a minute. There's one other thing that we need to know. And here's where you go to that district court clerk. You walk up to the clerk and you say, do you have any rules for this judicial district? And 99 times out of 100 she'll say yes. And you say, well, I need those because I'm a defendant in an action here. All right, so now you're going to have the federal rules and you're going to have that district court rules, and those are the criminal rules that you're going to play the game by. And then, just for good measure, ask, are there any other rules that this court is acting under or working under that I don't know about beside the district court rules and the federal rules of criminal procedure? There may be something in your state. You know, there are some real anomalies in some of these states. For instance, Texas and Louisiana are a couple of oddball states that we've been warned about. And I don't know of all of these little innuendos or idiosyncrasies, I guess is a better word, in the rules of procedure that they'll use, say, down in Louisiana where they have parishes instead of counties, or jurisdictions are different than they are here in Idaho. Now, always bear in mind that this course is being shot and it's being used and it's being practiced by students here in Idaho under the Idaho criminal rules. And the Idaho criminal rules do not apply in Illinois. Okay? They don't apply in Texas. But in Texas, you have your own rules. And those rules are going to apply. So you go to your local law library. This is the way we use that library. You go in and you get the criminal rules, and it's, you know, and they're all put together. They're not going to be much thicker than that. Here they charge us 15 cents a page. And you run over to the Xerox machine and you run those off, cut them out, and put them in a binder like this, and separate them out with loose leaf page dividers so that you're orderly. I can't impress upon you enough the absolute necessity for keeping your file folders and your information in an orderly manner so that you can put your fingers on it at a moment's notice. Because, friend, when you get into that courtroom, things happen fast, and they're moving fast, and you need information fast. Let me give you an illustration here. The other day I went into a court to argue the big three: the driver's license, registration, and proof of insurance. It's the first jury trial I've done in a couple of years, and you get a little rusty. So they drugged me clear up to the jury, and we went into the process. And so one of the things I said, well, Your Honor, let the record show that I'm sitting before the court and I don't have counsel. However, I do have counsel in the courtroom, and I'd like, at this time, like my counsel to take his place beside me. And so my counsel just got up and he sat down, and right away the judge said, well, now, is he licensed in the state of Idaho? No. Prosecutor, well, I object. If he's not licensed, he can't be here. Now remember, in your book called Legal Quotations, take a look under the subject matter of counsel on number 203, 4, 5, 6, and 7. Are some quotations from the Supreme Court of the United States. And so this little wimp, called a prosecuting attorney over here, he rose eloquently to the occasion, and he told the judge how the Supreme Court of the state of Idaho had already ruled on this subject matter, and how the legislature had ruled on this issue, and that unlicensed counsel could not act in the courtroom. So came my turn for rebuttal, and of course I had to say a few words, and I pointed out that I'm the defendant, and I'm the fellow who's going to prison, and I'm the fellow who's going to suffer the pains and penalties, and the prosecutor over here isn't. And that the court couldn't throw me out for being in there pro se, so if I'm competent to come into the courtroom pro se and defend myself, does it make any sense to the court to exclude my counsel? Does it make any sense to the court to say your counsel is less competent or qualified than you are? Would I employ somebody who's less competent than I am to carry out a specific task? And if I am inarticulate, and if I cannot present my case, and if I cannot cross-examine, could this guy do any worse? If I can't cross-examine somebody, the worst that could happen is that he can't cross-examine somebody. So what difference does it make which one of the two of us is incompetent? You'll concede that I have the right to come into the court and defend myself. Well, then I have the right to come into the court and defend myself with my next friend. Okay? The word next friend comes from the Brotherhood of Locomotive Engineers versus West Virginia, I believe it is, or the West Virginia Bar Association. You'll find that in one of these books. But remember, legal quotations. And so I quoted about 4 or 5 cases right out of legal quotations with the jury present. And I said, the Supreme Court of the United States says I've got the right to unfettered counsel, and if I'm denied counsel, why, that conviction is null and void, and that's called the, I think it was called the automatic reversal rule. Well, she went right ahead anyway and told me I couldn't have counsel, and that he could sit there and he couldn't talk, and he could just sit there, but he couldn't do anything. Well, Your Honor, if he can just sit here and can't help me, if he can't examine witnesses and cross-examine and advise me, I think he should probably sit over there where he'd have a better view. And I want the record to show that I'm being fettered, that my counsel is fettered, and that I'm not being given an opportunity to defend. And she overruled me. That's where I won the case, right there. Right there. Now, a little later on, my counsel leaned over and we were going to confer a little bit, and she just got real upset. This is a lady judge, and she just got real upset, and she said, he can't do that. You know what you do there? Listen to this line. Your Honor, is it the position of the court that I can't confer with my counsel, that I can't ask him questions? And she declared a recess. Get those lines on the record. The Supreme Court will love those. You know, the Supreme Court of the United States has put out more good lines to defend our freedoms and to defend our individual liberties than any other judicial body in this country, and probably any other judicial body that has ever existed in the entire history of mankind. There are probably some outstanding jurists from the 17th and 18th century. But I'm saying that the court in its general makeup right now is probably the best judicial body that I think we have ever seen pursuant to individual rights. And I just read a paper the other day. In fact, I'm going to put that paper in this lesson. I want you to read it. It was written by Justice Brennan. And would you back there make this notation to put that brief of Justice Brennan in with this tape? I think this is tape number 7. In which he said that the court has made a dramatic shift in the last 20 or 30 years toward adjudicating issues of individual rights, more so now than in times past where they were deciding states' rights issues. Now, what we're faced with now is, how do we keep our freedoms? How do we get that IRS off of our backs? How do we get the state police and the local police from harassing us? How do we, this everyday police state environment. How do we shake that off of us? Well, you know, I've said in the last few lessons here, the first thing you've got to do is stop volunteering and stop volunteering into mercantile equity and contract and get into being self-governed and responsible for your actions, whether it's on the road or whether it's in your everyday way of life. But the High Court recognizes that, and Brennan, Justice Brennan just wrote a magnificent article on that, and he delivered it last November. That was November of 1982 in Maryland. I'm not going to go into it in great detail. I want you to read that so that you can see and understand that when you're being made fun of and ridiculed and impugned, and these people are talking down to you from the bench and talking down to you from the prosecutor's table and telling you that you're nuts and that you're out to lunch and you don't understand the law and that these cases have already been decided and you're just a dumb layman and you can't know or understand anything, that the Supreme Court of the United States knows and understands your rights. And when that case gets to them, I can tell you how they're going to rule. You will be able to determine how they're going to decide, whether for you or against you, based upon these many, many decisions that you see there in legal quotations. Anyway, just take a look at that issue there on counsel. That's number 203, 204, 205, and 206. Now, there's one other that is extremely important. And note this down. It's number 173. I don't have that legal quotations book right in front of me, or I'd quote it for you. But I've quoted it before, and it's this one. That a pro se cannot be held to the same standards as a licensed lawyer. Let me tell you, when you get in that courtroom, they're going to sit there and hang that on you every time. They're going to sit there and say, well, we're going to hold you to the same standards as a lawyer. Do you understand that? Trying to bamboozle you and intimidate you into getting a lawyer. You see, as soon as that lawyer, whether he's a public defender or a private lawyer, comes in, he's now the lawyer of record or the attorney of record, and now you're reduced to the status of an incompetent. And boy, I'll tell you, you know, you can sit there and you lean over to your lawyer and you go, hey, psst, 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 psst. Sit down and shut up, Mr. Gordon. I'll take care of this. They'll just treat you like you're some kind of a boob. You can't talk or confer with a lawyer. No, I'm not saying that all the time, but as a general rule. And if you've got a public defender and you're ignorant, well, that's just nowheresville. So you've got to get rid of the lawyer, and then because you're going to act pro se, I've had judges come down on me off the bench. Do you understand, Mr. Gordon, that you could be sentenced to the state penitentiary for 5 years? And he'll just growl at you. Yes, I think I recognize that kind of jeopardy, and I believe there's a $10,000 fine that goes along with that. Now, I'd also like to point out to the court that pursuant to blah, 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 that a pro se cannot be held to the same standards as an attorney. So says the Supreme Court of the United States, and may I inquire at this time, Your Honor, if this court is bound by the common law and the Supreme Court of the United States? This particular judge I asked that to, he just kind of melted like a slug with a quarter pound of salt on his back, and he didn't have much more to say, and we got into the issue of the information. I said, I'm glad you brought that subject up, Your Honor, and I rose and I spoke for another 5 or 10 minutes on the subject of information. And I believe you got that little one sheet of paper there. There's a particular case mentioned there on this thing called information. It's much easier to defend yourself against felony than it is a traffic ticket, because remember, traffic tickets come under administrative law and contract and equity. And when you're going in there, if you've got a driver's license, you're guilty going in because you've got the license, and that's the prima facie evidence of intent. You know, a doctor who goes in and operates on somebody in his office instead of in the hospital, and the statute or the law says you have to do that procedure in the hospital, see, he's already guilty. It's just a matter of, did you do the act or didn't you do the act? It's not, did you intend one thing or another? Was it innocent or accidental? All right, now keep that in mind. There also, pursuant to rules of procedure in the court, are going to be specific statutes that may regulate some of the activities of the court, and you ought to be alert to the fact that we believe that's a violation of the doctrine of the separation of powers. when the legislature prescribes the rules of procedure that are to be used in the courtroom or who shall practice there, as they do here in Idaho. For instance, we have Idaho Code 3-104 and 3-420, which prescribes who will and who will not practice in the courtroom. Our state Supreme Court here said that they're not going to listen to any licensing standards set down by the legislature. And that's good, and I'm glad they've done that. I don't want my judges here listening to the legislature at all. The legislature passes the laws, the judge applies the law in the specific case. When the legislature starts telling the judges how they will perform, they're infringing upon that separate and co-equal branch of government that has the equal power of the legislature. I don't want to see that violated. But you're going to see specific statutes applied, and the lower court judges will just rubber stamp anything they see from the legislature because they come out of law school and law school tells them that the legislature is sovereign. I can show you about 6 or 8 or 10 other levels of authority that supersede the legislature of Idaho. The legislature is so far down the line of power over here is that it makes it ridiculous to talk about the sovereignty of the legislature. The legislature is sovereign in its authority over corporations, trade, commerce, business, and industry, not individuals. Now, I'm an individual and sovereign citizen. Now, it can't pass rules and regulations that would affect my rights. Remember, Miranda, page 491, where rights are involved, there can be no rulemaking or legislation that would abrogate them. And Marbury versus Madison. Now, you've got the Miranda case, and I think you've got Marbury versus Madison, which was decided in 1803. Now, the Marbury case was a matter of mandamus and a matter of rights. And I want to impress upon you here that when a case is decided in 1797 or 1803, it's just as forceful and has just as much vitality and vigor, as President Kennedy used to say, as any case decided today. The Supreme Court does not reverse itself very often. There probably are a dozen times where the Supreme Court has changed or reversed itself in the history of our country. I can only think of 2 or 3. And Marbury versus Madison is an issue of rights, and it claims that the Constitution is a superior law, superior document. It's way up here. And statutes and regulations and ordinances are way down here. So when we're talking about the Constitution, whenever you've got a statute, a rule, or a regulation that conflicts with it in any shape, form, or manner, it's just null and void ab initio, and that's the end of the argument. But the lower courts will uphold those statutes and ordinances. They'll uphold an ordinance concerning the garbage company before they will uphold the Constitution of the United States. Now, don't let that bother you, and don't walk out of that court, well, blankety blank, commie so-and-sos. This particular judge I was just referring to a little while ago really got uptight, and I said, excuse me, Your Honor, and I can see that you're a little upset there. Occasionally I'll throw a line in like this. Would you like to call a recess so that you can regain your composure? Once in a while I'll throw that line in, and I suggested to this judge that this court is not a court of competent jurisdiction, and the court couldn't decide these issues. There's no issues of fact before the court for the jury to decide. I've already stipulated that I don't have a driver's license, the car's not registered, and there's no insurance, and that I'm claiming that Title 49 doesn't apply to me, so therefore there are only issues of law. And if this court is prepared to make a decision based upon law, the Constitution, and rights, no, I can't make those decisions, she confessed. So she went back and called our administrative law judge here in this district, and he advised her to go ahead with the trial, get the conviction, and then let him appeal. And boy, I worked all afternoon, just 99 miles an hour, and sure enough, the jury came back guilty. Well, I was sad. You know, every time the jury comes back and they tell me I'm guilty, I sit there with this persecution complex and this rejection of my peers over here. I don't know if I've ever had a jury of my peers. These guys are all licensed drivers, and I don't think they understood what I was telling them. So now I go into the appeals process, and this appeals process will take me to Washington, and I've set my case now in concrete, so to speak. It's at that trial level that you set your case in concrete. Before the trial, you've put in your theory of the case, and you've laid out all of your arguments, and you've demanded counsel, and you've demanded a common law jury, and you've been denied these basic rights. Those are winning arguments of them by themselves. But the key issue that I'm arguing in this particular case is, do I have to have a driver's license? And that's what I want the Supreme Court of the United States to answer. To get those cases before the Supreme Court in your county or your state, it's going to require some time, effort, and energy. Remember, it takes 2 or 3 years to get that case to moving up the line to the Supreme Court. So it would seem after months and months and months and a lot of filings and rejections and filings and rejections, it gets discouraging. So I want to give you a little note of encouragement here as we close on this lesson. What you've observed in this lesson is the motion hearing. We went through the motion hearings, and we've got a pretty good judge, Judge Curtis. You know, he's a friendly sort of judge. And he gives us some friendly rulings, and he's not too stern. And he may be dumb as a board, or he may be knowledgeable, we don't know. But he isn't a prosecutorial judge. He's got his neutral hat on, and with that neutral hat, he's just making rulings. But you're going to come across judges that are going to just breathe fire and brimstone at you. And when that happens, and this fire and brimstone comes down, don't get discouraged. Don't let that bother you, because you're talking to this lowly sergeant or PFC, and he's screaming salute and jump through the hoop, and you better do this or I'll put you on KP. By the time you start moving up the line and you start talking to some judges with some knowledge, they're not going to laugh at you. I talked to a judge not too long ago that told me, you know, you're forcing us to blow dust off of books that we've never read before. I talked to a judge just the other day, and he said, you know, you probably have more knowledge pursuant to constitutional law than any judge in this district. I was surprised at his comment, because this judge is very knowledgeable, or relatively knowledgeable, in constitutional cases. And he mentioned to me, and I was really surprised when he said this. He said, I've read a lot of cases from the Supreme Court on constitutional law, and particularly on counsel. But I've probably read more than all of the rest of the judges in this district combined. And that's really surprising, because what that tells us then is that the judges are acting in the capacity of administrators rather than as judges. And that's probably relatively correct, because 99% of us are in juristic equity, and we've got licenses and permission, and we're acting in privilege, and so there's nothing else to do but to administer the law. They don't need to decide the law. Deciding the law comes in the higher courts. If we had 10 million citizens left in this country who are free men and who are going into the courts demanding rights, then I think that we would revert back, or we would at least force some courtrooms to open up and become common law courts. As it is in this country now, we've lost our gold and silver, so the substance is gone from our common law. Now what we're faced with is that we're all acting in privilege, in corporate privilege, I should say. And so therefore it's just a matter of deciding the terms of the contract, and so the judge is going to reduce to the status of administrators instead of judges. So, in conclusion then, let me recapitulate then what we've seen here in this in this tape, and what you must do now at this stage, at this level of your development. You've run through the lessons on status and the jailhouse scene, and by this time you're up to a place now where you're walking into the courtroom and you're making your plea, you're making your arraignment and plea, and now you're starting to argue motions. You may have a couple of motion hearings, and remember that one of the hearings that you're entitled to is a hearing to suppress evidence. All right? The hearing to suppress evidence, the bail setting, whatever type of hearing that you're having is simply a label or a name that's hung on the hearing as you walk in. And all these hearings now are before the judge. There's no jury yet. We're not talking about trial. We're setting down our theory of the case. We're laying out before the court the rules of the game. This is the way we're going to play the game. And they're saying, no, we're not going to play by your rules. And you're saying, we're going to play by the common law rules. Now, you've got a right to the common law rules, and they can't take that away from you. But they're going to do everything in their power to discourage you and to tell you, no, you can't. And they're going to laugh at you and ridicule you, make fun of you. And if you can't weather that storm, you're going to have to get out of the kitchen. Or how do Harry Truman word that? He said, if you can't stand the heat, then get out of the kitchen. I didn't tell you now that when you go into the courts that you're going to have an easy time of it. And you have to go through these lower courts, because the Supreme Court has said that they're not going to listen to these appeals unless you've exhausted all of your remedies within the borders of your state. So if you have to go to the traffic court, then you have to go to the traffic court and be humiliated. And then you have to appeal maybe to your magistrate, and then maybe to your district court, and then to your appeals court and your state Supreme Court. And when everybody in your state says, you're wrong, sit down, shut up. Remember that colored lady that rode the front of the bus? You know how many times she was rejected? First of all, she had to get on the bus and break the law. And then after she got that out of the way and they arrested her and hauled her off to jail and took her fingerprints and booked her and kept her in jail for several days and made her pay bail or bond and got out, she had to go to trial and the jury sat there and said, guilty! Can you imagine the rejection of that poor woman? And then she went to the next court. We affirm the jury's decision. And the next court, we affirm the lower court's decision. Until finally she got to Washington and the Supreme Court said, yeah, we think you've got a real issue here, lady. We want to listen to what you've got to say. And she laid out her story and said, I'm a black woman, and I'm a citizen of the United States, and I don't think that based upon race, religion, and color, you can compel me to ride the back of the bus. And the Supreme Court said, yeah, that's right. We agree with you. Finally, victory comes at the end of a long, arduous road. Things are different down in Alabama now than they were in 1964. And things will be different in your county wherever you are in 1990 or 1995 whenever you get those laws changed. And it's going to require somebody just like you, in whatever county you're in, to go through this process. The first thing you've got to do is challenge the law. And you can't sue. And I want to caution you against challenging the law without using the right process. Now, you know over in Illinois there's a little town there somewhere, I don't know if it's Marion or whatever this little town's name is in Illinois, and they passed this gun control legislation, an ordinance, banning handguns. Alright, that city can do that. You gotta remember that that city can control the trade, commerce, business, and industry in that city. They can't control the citizens. They can just control the trade, commerce, business, and industry. So they can force the sporting goods store to stop selling those guns. We don't have any problem with that. That comes under police power. I can show you a long line of police powers, and the Supreme Court will uphold them in that position. So some lawyer in that town has now sued and gone through 2 or 3 courts and has been turned down, and they've all recognized that that law is constitutional. He's going to take that law to the Supreme Court of the United States. He's asking the wrong question, and the Supreme Court of the United States is going to give him the right answer to his wrong question and uphold that little town's gun ordinance. Mark my word. You see if I'm not right. The Supreme Court is going to do 1 or 2 things. 1, we're not going to listen to your appeal. That's the end of that argument. Or 2, we're going to listen to it, and when they do, they're going to say, yeah, that little town can pass an ordinance, and they can absolutely prohibit the sale of guns. What he should have done is walk down Main Street with a gun on his hip and let the police chief arrest him and throw him in jail so he'd suffer a loss of his First and Second Amendment rights. And then after he suffered the loss of his rights, then he goes into the courts and screams rights. Then, where rights are involved, there can be no legislation that would abrogate them. But the man hasn't had any rights violated. And there's a big difference. He's suing, and the courts are turning him down because he has no cause of action before the courts. Poor guy's probably been to law school. All right, now, these rules, then, are absolutely necessary and imperative. So in this last hour now, what I'm going through here is this thing of the rules. And there are people all over the United States now that are watching these tapes. And I don't want you to go into that court like so many people do. Like, I'll never forget the first time I went into court. The headings on my motions said Colorado on them. I was so dumb, I just bought motions and filed them with the court and walked in and thought, well, now see, I put this magic paper in here, now the judge is going to dismiss it. All I did is sit up there and laugh at it. He said, Mr. Gordon, do you know where you are? Well, certainly, I'm in Idaho. Well, I'm checking here. I'm reading the motion that says, in the 3rd Judicial District of the County of Johnson, meaning Fort Johnson County, Colorado, and I don't really see the relevance of this motion here in the 5th Judicial District of Idaho. Could you explain that to me? And I'm, it's my first time in court. I couldn't walk and chew gum, let alone walk in there and tell him why that motion had a Colorado heading on it. So remember, when you're filing a motion, it's got to have the right heading on it. So you're going to need to check in your little local district and find out how do you put headings on. Just go into any lawyer and say, hey, you got an old brief or motion in here so I can see a heading? Could I have this? Give him a quarter for a page, and there you've got your heading. And then that's the heading you're going to put on. Every brief and motion, affidavit, or paper that you get from us, read it and see whether or not it applies. We have had in the past, and I've been guilty of this myself, you walk into court and you file 20 motions and never read one. I bought these from Gordon, and boy, he knows what he's doing, and so I'll just file these. And then you get into the motion hearing, and the judge says, let's see now, you're charged with not registering your car, and I see a brief here, and it's really well done on the money issue, and I see another brief here on the Title 26 lax jurisdiction. What does Title 26 of the U.S. Code have to do with the registration of your car, Mr. Gordon? And you're sitting there going, I don't know. Well, Mr. Gordon, I assume you wrote all of these motions. They've all got your name on them here, and it looks like 26 pages is a lot of writing for you to do. I don't really understand why you would write 26 pages on Title 26 of the IRS code here and bring it into this court. Could you explain that? You see, the good serious pro se, he writes his own paper, and therefore he's not anxious to write 20 pages on a subject that's not relevant to the case, is he? But when you're just paying out phony Federal Reserve notes and buying a lot of paper, and you think you're going to walk into the courtroom and drop this magic paper on the judge, and he's going to melt like a slug with salt on his back, I've got real bad news for you, friend. That isn't going to happen. So unless you're ready to take the heat that's going to come out of that kitchen over there, you're in the wrong game. Now, for those of you that want to do this and you want to get into the right game, then you're going to read that affidavit. And if there's something in the affidavit that doesn't apply to you, it doesn't apply to your state, it doesn't apply to your county, then you're going to use the affidavit that you get from us, and you're going to sit down to your typewriter and you're going to retype it. And you're going to delete that particular paragraph. Or you may find that there's something that you have to add to it. And you're not going to know that unless you have the rules of your district. And so I've had people say, oh, but Mr. Gordon, that's such a big book and it's just full of all those rules. Could you imagine the football team in the National Football League going out on Super Bowl Sunday and playing the game and they don't know the rules? Or a referee that doesn't know the rules? The game is played, friends, by the rules of the court procedure of your state. And if you don't know the rules, you can't play the game. And if you don't know the rules, you can't win. Just telling you. So if you think that you want to play and you don't want to take the time to learn the rules, then it's your problem in life, not mine. Now, that's the bad news. Now, the good news is you don't need to memorize these rules. You just need to sit down in the bathtub where there's a little privacy and you won't be bothered by the kids and the wife and the doorbell. And take your big toe and you flip the hot water faucet on and you get nice and warm and you sit there and you read it. Just read it. It all goes into your computer up here. Then, here's what will happen. You're sitting there in the courtroom and the red flag comes up. Somebody does something. Objection, Your Honor. There's some rule that covers that. And I don't know what it is. I think it's Rule 5 here. And remember, your rules of procedure, they start out logically. They start out with the warrant for the arrest, and they go through the arrest, and then the jail, and then the bail, and then the arraignment, and then the motion hearings, and on up the line, the probable cause hearings, and on up to trial, and then finally you're going to get up to Rule 54, where it says appeal. Isn't that logical? Rule 54 is appeal after conviction, and then back here, Rule number 1 is the warrant for your arrest. And everything that occurs in between is logically put in there. So as you're going through and you say, wait a minute, where am I? Motions. Well, there's an index in here that says motion. Gee, let's read about motions. So when you're filing motions, it'll tell you what day to file them on, what day to move to have them heard on, how you motion up a motion hearing day, Everything you need to know is there in the rules. So every time you have a proceeding, like arraignment, go to the rules and read the arraignment. That's one rule. I think in this state it's about Rule 4. Alright? So you look at Rule 4 a couple hours before you go into court and you familiarize yourself with the rules. No big problem. You walk into that courtroom and you handle the arraignment. Now the arraignment's behind you, right? Don't need to read the arraignment rule anymore. Don't need to memorize it. What's going to happen next? Now we got to have a motion hearing. Now you go to motion hearing. Take motion hearing and you file your paper and you just step 1, step 2, step 3, step 4, and that's all there is to it. Sounds simple. But boy, I'll tell you, the adrenaline's going to flow. And you're going to have some tough moments in there. From the book that's called Legal Quotations, every time you get despondent, you just pick up legal quotations and start reading what your Supreme Court, down there at the end of the road, remember, that's where you're going. You got a ticket. Now you're going to have it finally adjudicated by Chief Justice Warren Burger. He's the guy that's going to make the final determination. He and the other justices. Read your legal quotations and find out what your Supreme Court says every time you get despondent. That'll perk you right up. All right, I think that pretty well covers it. And so now you have the motion hearing and the procedure. You've had an opportunity to watch some people operate in the courtroom. The next step for you is to put on the swimming trunks and jump into the pool and start swimming. Now you need a ticket. And now you need a case to argue in the court so that you can get some practical experience.